Coming to the very first topic of today's discussion, this is with respect to religion, constitution and courts. In societies like India, religion forms a very sensitive topic. It forms the very core, the very integral element of one's culture, one's way of living. So it is but natural that we have had witnessed a lot of cases surrounding the religious disputes. For example, the temple entry rights, or with respect to the religious conversions, or with respect to the different rights exercised by various sects within a particular religion. So that's the one thing. The second thing which you'll have to understand is that the way in which the judiciary or the legislature or the executive looked at this particular issue of religious disputes, it has evolved with time. That is, the way in which they looked at these issues pre-independence is quite different from the way in which they look right now. And it is primarily because of the evolution of jurisprudence with respect to the religious disputes. The third thing which you'll have to understand is that there has been a growth of cases with respect to the judicial interventions in the matters of religion. And it is primarily attributed to the growth of awareness with respect to the individual liberties. So primarily, the religious disputes are nothing but, in a general sense, it's a fight between the individual liberties versus the community rights with respect to the faiths. And in this particular column, which has been published in the Hindu, what the authors are saying is that the courts have played a very important role and they have upheld the constitutional morality. They have looked at the issues of religious disputes from the lens of constitutional morality, and they should continue to doing so. So they have mentioned about two recent cases in which the Madras High Court has taken a decision. So what they are saying is that it is really important for the courts, for the constitutional courts, to basically look at these issues from the lens of constitutional morality. So what we are going to do today is we'll first look at this concept of secularism, a highly debated topic, a very important one. What secularism is all about? What are these two branches which separate the Indian secularism with the Western? What has been the evolution of jurisprudence or the legislative take with respect to the religious disputes over time, pre-independence and post-independence? What are the challenges with respect to the judicial interventions in the matters of religion? And what should be the way forward? Believe me, it's going to be a very important topic and a highly probable topic for the mains and a very important discussion. Part of GS2 fundamental rights. What the authors are saying is judiciary has ensured that religious practices do not undermine the constitutional principles. So we'll have a discussion with respect to that. Let's first talk about, in general, that what do we mean by secularism? See, secularism, in general, what it means is that the state has no official religion. That is, we are not a theocratic society. Any state, if it calls itself secular, that is not a theocratic society. It's not based on religion, right? Second thing is, the state maintains neutrality in the matters of religion. That is, it would not discriminate against a particular religion, or it would not be biased in favor of a particular religion. It would maintain the neutrality aspect. Third is, citizens enjoy freedom of conscience, their inner feeling of attachment with the God or with that universal entity, and the religious practices. So they are free to basically have any kind of religious practices. These are three general notions which describe what secularism is all about. But there has been a constant debate with respect to the Indian notions of secularism and the Western notions of secularism. See, let's talk about the historical context. Why we have this particular difference? Whenever we talk about the Western model of secularism, always remember that the Western model of secularism is born out of conflict. It is born out of conflict. And when I'm saying conflict, I'm trying to tell you the conflict between the church versus the state, right? There has been Protestant Reformation movements, right? Bloodshed. So therefore, it is the result of conflict. And also, as famously remarked by Thomas Jefferson, that once we talk about the Western model, it is nothing but a wall of separation, a clear wall of separation between the religion and the state, the church and the state. Once we talk about the Indian model, it is born out of diversity. Diversity. So the Indian model is born out of diversity. The Western model is born out of conflicts. Once we are talking about diversity, we are talking about the civilizational pluralism which we have valued over the years. We are a multi-religious societies, and that has shaped, or that has basically led to the evolution of Indian version of secularism. So what you can say is that once we talk about the Western model, it's a negative concept. It talks about the rigid separation between the state and the church. Whereas the Indian concept is a positive one, where what we say is that we respect all religions and the state has the authority to intervene in the secular aspects of religion, right? So what are the differences? Look at this. Once we talk about the Indian secularism, we believe in positive secularism, the positive aspects of different religions. We value that, mutual respect and agreement. Once we talk about Western secularism, it's a negative concept, a strict separation between the church and the state, no intervention by the state in the matters of religion. And religion is completely a private sphere. It should not be shown in the public, right? Once we talk about the state, we follow principled distance. What it means? That if the state wants, it can regulate certain aspects of religious practices. Principled distance. Once we talk about the Western secularism, the state cannot intervene in the matters of religion. Then state intervention permissible for reform and welfare. And over here in the Western, it is minimal. Minority rights, explicit protection. We have Article 29, Article 30, which protects the minorities. So that's the very positive notion of secularism, right? Over here, we value the individual rights, not the minority rights. Then we have Uniform Civil Code. So we have the directive principles under Article 44, which directs the state to go with the Uniform Civil Code. Over here, there is no such issue, right? So this is a basic difference between the Indian and the Western model. Now, once we talk about the religious aspects, what the Constitution talks about, and these are very important constitutional provisions, also important from the perspective of prelims. We have the very important Article 14, equality before law and equal protection of laws. See, once we talk about Article 14, it talks about these two concepts. Equality before law. It's a negative concept, right? Which talks about the absence of privileges. Once we talk about the equal protection of laws, it's a positive concept, which talks about that similarly situated people should be treated in a similar manner, right? Then we have Article 15, which basically 15 subclause 1. It prohibits the state to discriminate on the grounds of religion, race, caste, sex, place of birth. Then we have 15 subclause 1, subclause 2, which basically says that no one would be subjected to any liability, restriction, or disability as far as we talk about the access to the public places, the bathing ghats, on the basis of religion, race, caste, sex, place of birth. So over here, one thing again becomes important to understand that 15 subclause 1, it is a vertical right available against the state, whereas 15 subclause 2, it's a horizontal right available against the state as well as the individual. A very important notion, can be asked in the prelims, right? So overall, Article 15, it's a horizontal right, where specifically 15 subclause 1 is a vertical right and 15 subclause 2 is a horizontal right. Then we have freedom of religion. We have Article 25. We have Article 26. Article 25 talks about the inner freedom, the freedom of conscience, and the right to freely profess, practice, and propagate religion. Or we have Article 26, which talks about every religious denomination or section thereof will have the right to manage its own affairs, to have its own properties and to manage them, right? So again, these are the articles which provide, or the fundamental rights which provide for the freedom of religion, right? Then we have Article 29 and 30, which talks about protecting the distinct language, culture, or script. 30 talks about the rights of the minorities to establish the educational institutions. So we have explicitly provided the rights for the minorities also. That is what makes the Indian secularism as a positive aspect of secularism, right? Now, once we are talking about Article 25 and 26, something is very important. Article 25 and 26, they are qualified rights. What do you mean by qualified rights? Article 25 very clearly says, subject to public order, morality, and health, all people would be entitled to the freedom of conscience, and the right to freely profess, practice, and propagate the religion. So also there is one condition. So Article 25 starts with the exception part. It says subject to public order, morality, health, and to the other provisions of part 3rd. All people would be entitled to freedom of conscience and the right to freely practice, propagate, and profess religion, right? So we have the conditions of exceptions in place. Similarly, once we talk about Article 26, it again has exceptions subject to public order, morality, and health, not the other provisions of part 3rd. So these are qualified rights. What it means? If I am saying that Article 25 and 26 are qualified rights, the state and the judiciary can regulate the religious practices subject to these conditions. So that is what gives the power to the judiciary and the state to intervene in religious practices, right? So this is what you'll have to understand. Now, what has been the historical evolution with respect to the judicial and legislative sense once we are talking about the religious disputes? If we talk about the pre-constitution era, it was treated as an issue of civil entitlement. The very first case was of Shankaralinga Nadan versus Raja Rajeswara Dorai of 1908, where we had the Nadar community and its access to the Kamudi temple was questioned, right? So they basically petitioned in the court that why aren't we allowed to enter this particular temple? So the case went to the Privy Council in London and it was adjudicated. And the case was seen not from the angle of any of the rights, but as civil entitlement. So it was a civil case, right? Then we have the Madras Hindu Religious Endowment Act of 1927, which provided for that the state would have the power to supervise different temples to make sure that they have the power to decide the committees with respect to the temples, or the appointment of priests, or the auditing of the temples. So there was an explicit clause which provided for state interventions in the working of the temple, in the organization of the temple, right? Now, post 1950, what we have seen is the constitutionalization of religious disputes. We came up with the part 3rd in the Indian Constitution, which talks about the fundamental rights. So we are giving values to the fundamental rights. Whatever disputes are being adjudicated, they are being adjudicated on the basis of whether they are in line with the fundamental rights or not, right? Adoption of the Constitution with Article 25 and 26, which talks about the freedom of religion. The Article 25 talks about the freedom with respect to the conscience and the right to freely practice, propagate, or profess the religion, whereas Article 26 talks about the right to manage the religious affairs, right to buy properties and to manage them, right? Courts have examined the various temple disputes after the commencement of the Constitution, not as civil matters, but rather on the grounds of whether they are in line with the constitutional principles or not. So there has been the exercise of constitutional jurisprudence in the matters of religious disputes. And what has been the statutory framework? See, this is what the courts have been doing. Courts are looking at the religious disputes from the angle of the constitutional provisions, from the lens of the constitutional provisions. On the other hand, we have the statutory framework. We have the legislature coming and controlling the secular aspects. Now, why this is possible? Because we have Article 25 subclause 2, which provides that the state can make any law and it can regulate the economic, the financial, the political, or the secular aspects of religious practices. So state can definitely regulate that. Throw open Hindus institutions of public nature to all sections of the Hindus. So that is what gives the power to the state to intervene in this aspect, right? We came up with the Hindu Religious and Charitable Endowments Acts. Various states, for example, Tamil Nadu, Madras came up with the Madras Hindu Religious and Charitable Endowments. Later it was renamed as Tamil Nadu. Karnataka has come up with that. Various states have come up with these Hindu Religious and Charitable Endowments Act. Primarily, the very objective is to regulate the activities of the temples or various endowments, to decide that who is going to be appointed as the priest, what is going to be the framework with respect to the auditing of these temples, right? So what we can say is that the state is intervening in the matters of religion. It is not a private matter. It's not purely a private matter. The state has the authority to intervene in the workings, in the organization of the temple. Then judicial oversights. We have had many cases where judiciary has intervened. Even now, there have been cases with respect to the qualifications of the priests in various temples, and various high courts have given their verdicts that whether we should abide by this or not, right? Now, what have been the various tests and principles which have been developed by the courts, right? What have been the various doctrines, in essence, which have been developed by the courts? The very first case can be seen in terms of the essential religious practices test, the ERP test, which was evolved in the very famous Shirur Mutt case of 1954, Shirur Mutt case versus State of Karnataka, where what the court said was that in a particular religion, there has to be the determination of certain practices which are essential component, which are integral component of the religion, and to differentiate the essential practices with that of the customary or secular practices. In normal circumstances, the courts would not interfere with the essential practices, but they can basically intervene in these customary or secular practices in order to make sure that they are in line with the fundamental rights. They are in line with the principles of constitutional morality. And what constitutional morality comprises of? It primarily comprises of the objectives which are enshrined in the preamble, that of the equality, fraternity, justice, liberty, right? And this introduces objectivity. To introduce objectivity, that which particular practice is an integral component of the religion and which is a practice which is secular, which is amenable to change, which can be changed, right? Then we have constitutional morality, the very important case of Indian Young Lawyers Association versus State of Kerala, popularly known as the Sabarimala judgment. So we had the women from the age group of 10 to 50 of the menstrual age group. They were prohibited to enter the sanctorum of the temple. And what the court said in this particular verdict was that this is unconstitutional. It is biased. It is violating Article 14. It is violating Article 25. And what they said was that constitutional morality is supreme. And it quoted one of the very important judgment made in Navtej Singh Johar case of 2018, Navtej Singh Johar versus Union of India of 2018, where the Supreme Court very categorically and beautifully said that constitutional morality cannot be allowed to be martyred at the altar of social morality. We cannot give undue importance to social morality. Rather, we have to give importance to the constitutional morality. And it is the constitutional morality which permeates into the rule of law. It is the constitutional morality which determines what is going to be the rule of law. Very important lines. And in this particular case, what the Supreme Court, it went a step further. Because previously in Shirur Mutt case, what it said, that we will have to differentiate the essential practices versus the customary or secular practices. And these customary or secular practices, they can be changed. They can be, over here we can make an intervention in order to align these practices with the fundamental rights. But in this particular case, what the Supreme Court said, that even the essential religious practices are subject to change. If they are not in line with the constitutional principles of equality, fraternity, liberty, justice, so they can be struck down, right? Right to worship and practice has been a constant evolution with respect to the Supreme Court. So it has allowed various, sects or various groups. In Bijoy Emanuel case, the rights of different sects were very clearly specified. And even in this particular article, what the authors talk about is this: the rights of the Tenkarai sect to recite hymns at the Kanchipuram Varadaraja Perumal temple. So we have had debates which primarily were the contestations between various sects in a particular religion, whether they have the right to worship or not. And Supreme Court has taken a very broad view regarding this, right? Now, what you'll have to understand is that why we are witnessing the religious litigations. More and more cases are being petitioned in various courts. Why is it that so? One reason which I already told you, that there has been a growth. There has been a growth with respect to the awareness of rights. People are more aware of the individual liberties. And whenever you have a particular practice in a religion which counters or which is basically prohibiting or hampering the individual liberties, then they are subject to questions. So what we are right now witnessing is the ideological polarization within the religion or among different religions. Then we are also witnessing the sectarian rights. Different sects in a particular religion, they are contesting for their rights. because one particular sect, allegedly, it is dominating over the other and it is compromising the interests of the other sect. So therefore, the other sect also want to exercise equal rights, and therefore we are witnessing more number of cases. Then we have the aspects of tradition versus equality. Tradition says something which goes against the equality principle. So therefore, it is bound to be questioned in the court of law, right? So these are the issues, primarily because of which we are witnessing the cases of temple entry movements. There have been what are going to be the rights with respect to temple entry, whether a particular community would be allowed to enter the temple or not, or a particular gender would be allowed to enter in a temple or not, or with respect to the religious conversions. So we are witnessing the flood of petitions. Now, what are the challenges? In this particular regard, once the courts are primarily intervening and taking a stand, what are the challenges which are involved? The very first is the doctrinal ambiguities. See, what you'll have to understand is, in the very famous Shirur Mutt case, Supreme Court came up with the essential religious practices test. But there are issues with respect to the ERP. The very first is that the interpretation is being done by the judges and they lack the aspects of theology. So they are not experts in theology or the science of religion or the study of religion, but they are interpreting the theological aspects on the basis of constitutional provisions. So sometimes it counters the traditional beliefs and customs of the people. Second thing which you'll have to understand is that there has been an inconsistency. Inconsistency with respect to the application of ERP, essential religious practices, among various religions. What people perceive is that there has been a discrimination against one particular religion, or there has been a bias in favor of one particular religion. So these are some of the issues. So again, there is this aspect of subject matter overreach. See, judges, what you'll have to understand, that they are not experts in theology. They are being told of what a particular practice is all about, and then they are deciding on the basis of constitutional provisions. But religious practices, according to what people say, the petitioners, they have been in that particular phase. They have been in practice for thousands of years. So that is a question which remains. Then we have secularism misunderstood. In India's case, as we started the discussion, we follow a positive concept of secularism, a positive notion, right? Where we have equal respect for all religions. And we also accept those secular practices of a particular religion, and different people can follow it. Whereas in the Western model, there's a strict separation between the church and the state. But right now, what we are witnessing is that courts are pronouncing those verdicts, which basically push the religion as a private sphere. So we are witnessing a shift towards the Western separationism. Ideally, we should not follow this separationism. We have our own concept, but because of the rise of the awareness of the individual liberties or the fundamental rights or the constitutional morality, the concepts of constitutional morality, what we are witnessing is that religion is now being pushed as a private sphere, as a matter of private sphere, which is again a characteristics of the Western secularism. Then we have practices versus fundamental rights. It is very difficult to come up with a fine balance between what one particular practice is a particular practice in line with the fundamental rights or not. It's a very difficult question to be solved. And in different cases, the courts have taken different parameters to judge a particular case. So there has been an inconsistency. Then we have federalism and personal laws. What we are trying to say through this, we have, for example, different states coming up with the different personal laws. Civil rights. We have states like Uttarakhand, which has recently come with the Uniform Civil Code. So this is a state subject where states have come up with their own rules and regulations. On the other hand, we have different temple rights, or how the temple would be organized, the committees would be organized, the supervision with respect to the temple, how it's going to take place. Different laws have been made by different states. But the issue is that once you have the petition with respect to one particular religious dispute, it goes in various high courts. Various high courts, many of the times, have taken various stands. And then the matters goes to the Supreme Court. So there are issues with respect to federalism and personal laws, because we have different personal laws, civil rights in different states, right? What should be the way forward? What should be the way forward with respect to judiciary in particular? if there is a judicial intervention. The very first is there has to be a clarity. There has to be a clarity with respect to the doctrines the Supreme Court is coming up with. If the Supreme Court is coming up with a particular doctrine, there has to be the consistent application of that doctrine to all the religions, first of all. And whenever the doctrine is being implemented, there has to be a particular framework. Inputs must be taken from the theologians who have a base, who have a subject matter expertise in the religion, right? There has to be uniform and transparent framework. Then we have judicial restraint with sensitivity, especially in the matters of religion. Judiciary should not pass those verdicts which are of extreme nature. See, again, that has to be in line with the constitutional principles. Nobody is disregarding that. But what happens that if judiciary passes a verdict which is of extreme nature, then that basically creates resentment among the people. And then that further adds to conflicts in the society. It basically affects the harmony in the society. And the very base of Indian secularism is based on harmony. That is what you'll have to understand. Balanced secularism in practice. We need to emphasize upon our own concept of secularism, that is positive secularism. If we separate the religion from the state, or if we push the religion to the private sphere, we are in a way adopting the Western notion. And that is something which again is based on the binary aspects. It is a complete, what it says is that there's a pure difference between the interest of the state and that the interest of the religion. So we'll have to come out of this binary because we have a positive concept where the state can definitely intervene in the secular and the financial or the political aspect of religious practice. Then we have dispute resolution mechanisms. Why can't we come up with the special benches in different high courts? Or pre-litigation. Why can't we have a kind of a gathering of different people where through arbitration we resolve the conflicts? Why there is a need for increase in the litigation? Different theologians, different community members, eminent people of different communities can come together and discuss. If there is a dispute among religion, we can have people from different religions coming and discussing. Or if there's a dispute in a particular religion, within a particular religion, then we can have the interlocutors. We can have people from different sects coming together and discussing, right? Next, we have public education and awareness. There has to be a focus upon creating awareness with respect to constitutional morality. People should value constitutional morality more as compared to social morality. Traditions and customs, if they are infringing any of the fundamental rights, they should not be accepted. Right? So there has to be a growth of awareness. That is very important. Definitely it would lead to more petitions, but it would also lead to more egalitarian society. A society which gives importance to all the genders and all the classes and all the different castes in a particular religion. So that is what you'll have to understand. So what we are trying to say is that judicial intervention is important, but there has to be some sensitivity involved. Because in the matters of religion, it's a very sensitive issue. So there has to be the incorporation of the theologians, incorporation of those people who have subject matter expertise in this particular domain. Because if the judiciary comes with a particular verdict, which is, even though if it's based on the constitutional morality, if it creates the resentment, then definitely it would add to the conflicts in the society and it would affect the harmony aspect. I hope it's clear. Let's have a mains practice question. It says, Indian secularism is characterized by principled intervention rather than strict separation. Discuss the evolution of religious jurisprudence, what all things we have discussed with respect to pre-independence and post-independence, associated challenges, and suggest a balanced way forward. Very important topic. Please do write 15 marks, 250 words. Let's go to the next topic.